Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with some updates for you guys. Of dealing with the whole R. Kelly case. This is stuff that came out today. I'm going to try and rush through this video because my battery is dying on my phone. I was watching a Periscope video, and Periscope just drains your battery real quick, and I didn't know that I was going to do this video, so I'm going to try and get as much of it in as I can. So the first story, a judge has ruled that Drea Kelly can get her $20,000 child support payments out of R. Kelly's royalty checks. And this article comes from the Chicago Sun-Times, and it says R. Kelly's ex will be able to skim child support payments from his music royalties after the jailed R&B singer again fell months behind in payments of his 3 children. And we shouldn't say children, they are grown adults. The only one that really should be getting child support is the son. But anyway, after a brief hearing Monday at the Daly Center, most of it conducted in Cook County, Judge Lori Rosom's chambers, lawyers for Kelly and his ex-wife Andrea Kelly emerged with an order allowing the singer's $20,000 monthly payments to be deducted from payouts from his music distributors. Kelly and May paid child support to cover payments through July, but has not made a payment since, said Alison Mota, lawyer for Andrea Kelly, which I thought Steve Greenberg said that he had paid through August. But anyway, the man is locked up, so how do you expect him to be making child support payments? And this just goes to show that when Drea gets hers, she is going to get it royally, okay? Because she is just being trifling, lazy, and them kids need to get a job. I mean, like, I cannot believe his lawyers have not gone in to argue to have the child support to those 2 adult kids, Buku and what's the other one's name? Begins with the J. Jada, is it? Something like that. Whatever the 2 girls, they're adults now, and his attorneys need to go in and have this stopped. And so it says that Kelly owes more than $60,000 currently. And then it talks about the fact that he's behind bars, and then it goes on to say Kelly's lawyer, Steve Greenberg, said the singer's accounts and assets were seized by federal authorities after his July indictment, which is a total contradiction because, number one, we know that Azriel and Jocelyn are still living in Trump Towers. And number 2, the feds have already said that the money is going to a friend, that all the royalty payments are going to a friend of his. That was part of their reasoning for denying him the to be released out on bond just last month. So I don't know why Greenberg keeps going into court with these shenanigans. It says that Kelly was dropped by his record label earlier this year, and while streaming music services have continued to make his songs available, they have ceased to promote Kelly's music, limiting the income generated from his catalog, which we know that Sony isn't promoting him. Sony hasn't promoted him since they took over his contract back in 2012, I believe it is. But since the R. Kelly docu-lies came out, his streaming numbers have actually gone up. He's getting like close to 5 million streams every month on his music, and people are still playing his music. So anyway, and then he says that he has no access to his information and no real knowledge of his finances, and if he has adequate funds to make payments, he would make payments, Greenberg said. He has never shirked his responsibilities. In interviews before he was jailed in federal charges, Kelly had said his finances were in disarray despite a decades-long career as a chart-topping artist. After his arrest, in Cook County in February, Kelly spent 3 nights in jail, blah, blah, blah. It says a few weeks later, he was locked up again for unpaid balance of child support and related expenses that totaled more than $160,000, and again had to spend 3 nights in lockup before he could raise the 6-figure sum he needed to get out of jail. Greenberg's co-counsel in the child support case, Lisa D'Amico, withdrew from the case in September and has asked Rosen to order Kelly to pay her $12,000 in unpaid fees. And you guys know I talked about that in my last video, so you can go and check that out. And so, what do you guys think about Ms. Drea? Like, she just will not give it a rest. And I think, Buku, she'll be 23 in March. So we know he will no longer be paying for her because I believe he had agreed in the divorce documents that he would pay for child support and college tuition until the kids were 23 years old. So I believe Buku would be 23 in, I think she'll be 23 in 2020. Or no, maybe she'll only be 22 because I think she was born in 1998. So no, he still has like another year or so. But Drea really needs to stop. Now, speaking of R. Kelly and his financial situation with Miss Drea, you guys keep asking me my thoughts on that defense fund. And I keep telling you guys, people can give their money to whatever they want to give their money to. What I will say is this. If there really is a defense fund, and Doug Anton is getting this money for this defense fund, then why don't they go and pay off R. Kelly's child support? Why don't they take that money and just give it all, put it on the books at the child support court, okay, then let Drea get her money. And then that, will prove to people that the defense fund is real. You'll get to see how much money has been donated to the defense fund. I don't care what people give their money to. It's no different than when you go to church. There are people that sit in church every Sunday getting the word, okay, but they're not giving their money to that preacher. And they say, they don't look at it as giving the money to the church or giving the money to ministry. If they don't like the preacher, they will not give their money because they think that the preacher is going to mess over the money. And then you have people that, believe in the Bible, believe that they should be given 10% of their earnings, and regardless of what the preacher says or does, they are giving their money in good faith that the preacher is going to do with the money what the preacher says he's going to do with the money. And so you have to look at it that way. Either you believe the money is going to a fund that is going to benefit R. Kelly and you give to the fund, or you don't believe it and you don't give to the fund. But what I will say, this is my only true opinion about the situation. Doug Anton, and the fact that, not that he has gotten caught up in this whole defense fund thing, but the fact that he is having conversations with people, that he is, that anybody can pick up the phone and call him and he answers the phone and talk to people and try to answer these questions, that he's going on Twitter and doing all of this is so unethical, in my opinion, that there is no way he could represent me. There's no way he could be on this case. And the fact that he's still on the case has me looking at Steve Greenberg with the side eye even more, because you're allowing this to take place. And when I tell you guys, I know attorneys, okay? I know a lot of attorneys. I'll just put it that way. I used to date an attorney, a corporate attorney. And I am telling you guys, I have never seen anything like this before in my life. I have never known an attorney to carry on the way that Doug Anton is carrying on, talking to these YouTubers, responding to people on Twitter, just, just commingling with people, with questionable people associated with this case. It just boggles my mind. And when I'm talking to certain people and I'm telling them, like, you guys are not going to believe what's going on, and I'm sharing, the information, that's going on around this defense fund, I have yet to find an attorney who says, like, oh, that's okay, that's no problem, that's cool. Every lawyer that I know or that I communicate with, I got lawyers on my Facebook page, lawyers in my family, people that I grew up with that have become lawyers. And no matter who I talk to about this case, they are just like, what in the hell is going on? And like some of them say it's unethical. Some of them are saying that, it's okay, but it's tacky as hell. But none of them say that they would do what he is doing, that there was like, if somebody called their office and said, oh, I'm a YouTuber, or I'm, a fan and I want to know this, I want to know that. They said that they would never get on the phone with such people, with a blogger or anybody, and that if somebody called their office, they would instruct their secretary or their receptionist to tell them that, we don't discuss our client cases. We have nothing to do with it. I'm just amazed. And that's my only thought, is that at this point, in the beginning, Doug Anton was a character, and I was like, Lord have mercy, Steve Greenberg just going out there rounding up anybody to be on this man's case. And now he has pretty much solidified my feelings on that. And so it's just, the whole situation is just crazy to me. So, as I've said to you guys before, you don't have to keep, inboxing me, asking me what I think about this defense fund, because I could care less about this defense fund. I could care less what you do with your money. The only person's money that I'm concerned about is my own money, okay? And I do with my money whatever I please to do with it. And I suggest to everybody else that whatever decisions, financial decisions that you make them soundly, and that you are okay with whatever decision you make. And my only real opinion on the whole situation is that I think that Doug Anton is just acting very unethically and not in the best interest of R. Kelly and R. Kelly's case. And then I thought R. Kelly was supposed to have court on the 29th for I don't know if they're still going to have court, because I thought it was about him being released on bond in Chicago, but maybe he's back in New York. I'm not sure. But this story here says that, and this comes from Bossip, so I had to go and get the actual documents myself, but I will go ahead and read what their little blog has to say. When it comes to trying to get out of jail, R. Kelly is taking a page from his former business manager's playbook. Lawyers for the singer filed a motion to dismiss charges related to his federal case, citing the same motion that his co-defendant, Derrel McDavid, filed last week. And I do have those documents, and I'll read them. McDavid asked the judge to dismiss the charges that he co-conspired with Kelly to obtain and destroy tapes involving him and others between 1997 and 2002. The R. Kelly employee's argument is that the alleged offenses in question occurred after the statute of limitations expired in 2014, which make them ineligible for prosecution. McDavid said that the feds can't prove that he and Kelly criminally conspired to get rid of films involving Kelly after 2014 and want the charge thrown out immediately. Kelly must have wholeheartedly agreed with McDavid's contentions, because he filed the exact same motion on October 28th, according to court papers obtained by Bossip. And then it says a judge has yet to rule on the motion. Kelly is due back in court this week. His simultaneous federal case in Brooklyn, New York, which accuses him of running a criminal enterprise for years. That's the end of the article. So you guys know how I do. I get the documents and I read them to you. So from this point on, I'm going to be reading the documents. The motion to dismiss Section 5 of the criminal indictment, showing that Derrel McDavid and R. Kelly conspired to conceal information to get people to give false testimony. And basically what they're going to be saying in this motion is that the statute that won the videotape does not qualify under this United States Code 1519, and that, you know, that was intended for financial institutions that are destroying financial records, that it doesn't go to a videotape because no one would realistically have financial records on a videotape, and that these financial records have to be destroyed to cover up a crime. And they're saying that the videotape in question is showing pornography, is not concealing any type of financial documents. Then they go on to say that, you know, if there was a conspiracy going on, that R. Kelly and Derrel McDavid would have had some kind of reason to believe that, you know, 10 years after he went on trial and was acquitted, that the federal government would come back and bring these charges against them. And so they were saying that that's unreasonable for them, you know, to think that that would have happened. And one example that they give is like a police officer who files a false police report in a state level crime. He would have reason to believe that a federal civil rights lawsuit could be filed. So if he's falsifying the documents in the state level case, he has reason to believe that a federal case could come up down the road. But they're saying that in R. Kelly's case, that was unreasonable because, you know, he went on trial, he was acquitted, and as far as in a reasonable mind, that was the end of it, that he had no way to believe that the federal government would then take on this case, reopen it, you know, 10, 11 years after he was acquitted, and bring him up on charges. And so they're saying that this United States Code 1519 that they're trying to apply to the case does not apply, and that they need to dismiss these charges. And then they go on to talk about the money that he allegedly paid to Rishana Landfair and her family and to Derrel McDavid. And they were saying that there's no justification or reason why in 2015 that R. Kelly would have been paying money to Derrel McDavid or to the Landfairs to conceal or cover up the case that took place in 2008 when, you know, everything had already been revealed. The government claimed that they had this videotape that he was on trial for, so everything had been revealed, so there was nothing to conceal, and that there was no reason for him to be, you know, continuing to make payments when he had already been found not guilty. And they talk about these two payments that he allegedly made to Rishana for $1,150, and then two payments that he made to Derrel McDavid, one for $80,000 and one for $100,000. And you know, they're basically saying that it makes absolutely no sense, and that the government has failed to provide, you know, discovery that links those payments to anything that happened in his 2008 case. And so I'm going to go ahead and, you know, read the better part of the motion that they filed. But once again, they said that Steve Greenberg turned around and filed the exact same motion on R. Kelly's behalf, you know, which is crazy, but typical Steve Greenberg. So if you want to know what's going on, take a listen. If not, I just gave you the summary. of what was going to take place. And so, guys, that's it for me. Leave your comments below. Let me know what you think about Drea being able to get this $20,000 out the top of his royalties. And what do you think about Steve Greenberg piggybacking off of Derrel McDavid's lawyer's motion to dismiss at least one of the charges in the count against them in the, I guess it's the New York case. For some reason, I thought Derrel McDavid was part of the Illinois case, or maybe he is, I don't know. But anyway, this is what they're saying in this motion to dismiss. So this is the motion to dismiss count 5 of the indictment, and this was filed by Derrel, on behalf of Derrel McDavid, by his attorneys, and the attorneys are Blair T. Westover, Bo B. Britley, and Vadim A. Glosman, and they asked the court to dismiss count 5 of the indictment for failure to state an offense that occurred within the statute of limitations. And so they're basically citing a United States Code 1519 that deals with destruction of evidence. And so it says that the indictment in the case charges Mr. McDavid with conspiring with co-defendant Robert Kelly and others to alter, destroy, mutilate, conceal, cover up, falsify, or make a false entry into a record, document, or tangible object in violation of 18 U.S.C. 1519. And so the indictment alleges that between 1997 and 2002, Mr. Kelly engaged in acts with 5 people and videotaped those acts. R.1 at 5. In April of 2000, the state of Illinois began an investigation into Mr. Kelly regarding his contact with certain persons. Mr. Kelly was acquitted of those charges. ID, in summary, the indictment in the instant case alleges that Mr. Kelly and Mr. McDavid acted to obtain videos of acts with persons and to convince various witnesses to deny any contact with Mr. Kelly, R.1. And there are certain words that are being used in this indictment that I'm not going to use. So you guys are going to have to just figure out when I'm skipping over certain words or not making certain statements. And so it says, Mr. McDavid now asks the court to dismiss count 5 of the indictment against him pursuant to Federal Rule of Criminal Procedure 12b-3. Quote, to be sufficient, an indictment must state each element of the crimes charged, provide the defendant with adequate notice of the nature of the charges so that the accused may prepare a defense, and allow the defendant to raise the judgment as a bar to future prosecutions for the same offense. United States versus Nyack, and then it gives the case number, and this was a case that was heard in the 7th Circuit in 2014. And it says, in determining whether an indictment states an offense, the court must accept the allegations in the indictment as true. United States versus Moore, and this was in the 7th Circuit in 2009. The problem with the government's indictment is multifold. First, the defendants cannot conspire to conceal, cover up, or make false entry into a record, document, or tangible object within the meaning of Code 1519 if none of the objects identified in the government's indictment qualifies as objects under 1519. The only objects identified within allegations contained in the indictment as it relates to Mr. McDavid are videotapes. These videotapes do not constitute a, quote, record, document, or tangible object, as those terms are used in Code 1590, nor does encouraging witnesses to provide false statements to state law enforcement constitutes concealing, covering up, or falsifying a, quote, record, document, or tangible object, end quote, within the meaning of Code 1519. The specific conspiracy charged in the charged by the government was to violate Code 1519. Conspiring to destroy evidence which falls outside of Code 1519 cannot constitute a conspiracy to violate Code 1519. Similarly, conspiring to suborn perjury to lie to law enforcement in a state investigation does not constitute conspiracy to violate 1519. Second, the indictment fails to allege the appropriate mental state. In order to be convicted under Code 1519, the defendants must act in contemplation of a possible federal investigation. In this case, Mr. McDavid's conduct was, by the government's own allegation, motivated by the desire to either impact the state investigation or keep information from the public at large. The government does not allege that the defendants ever considered or anticipated or acted with any thoughts regarding any possible federal investigation. Third, the statute of limitations for the alleged offense ran on July 11, 2014, R.1. The government must allege and prove an overt act occurred after that date in order to extend the conspiracy such that it is not barred by the statute of limitations. As discussed below, none of the acts identified in the government's indictment as occurring after July 11, 2014 furthered the purpose of the charged conspiracy or were within the charged conspiratorial agreement. So their argument is, one, the government fails to allege that Mr. McDavid and Mr. Kelly conspired to destroy an object contemplated under the tangible object provision of Code 1519. And so they go on to cite like a whole bunch of cases where the courts ruled that it wasn't, that the code under 1519 wasn't eligible. And so basically they're saying that this U.S. Code 1519 came about during the Arthur Anderson case from a while back, and it was where this accounting firm destroyed all of these documents, incriminating documents. And so they go on to argue for the next few pages that these videotapes were not documents or written documents that would have been held, like you wouldn't take a videotape and record written financial records and then destroy the videotape because these financial records were on the videotape. They're saying that this code is specifically about destroying records that have incriminating information as it turns to financial records, and that what was alleged on these videotapes would be like if you went fishing and you caught fish that you weren't supposed to catch. So like how here in Florida we have grouper season and you can only catch grouper during certain months. So if you got stopped by a federal agency like the Coast Guard or something and you had grouper on the boat and you threw the grouper out of the boat, you couldn't use this code 1519 to charge the person because a fish isn't a financial document. It isn't a matter of record keeping. Like you don't use the fish to keep records to cover up something else that you're doing. And that is the same as with this video, that they can't say that they destroyed the video to cover up this conspiracy, that there was this organized crime going on. The Supreme Court indicated that the statute was specifically directed at file keeping. Quote, although many of those verbs could apply to nouns as far-flung as salamanders, satellites, or sand dunes, the last phrase in the list makes a false entry makes no sense outside of file keeping. And so it says, to that end, the Yates court held that, and that was a case, Yates court held that a fisherman who tossed an oversized fish overboard to avoid that fish being discovered by a federal agency did not destroy a, quote, tangible object within the meaning of Code 1519. And then it says, while a fish, like any other physical object which exists in the world, can contain information in some ontological sense, in parentheses, it contains the size of the fish, if nothing else. That is not the type of information that Congress intended to fall within the meaning of Code 1519. Then it cites United States versus McRae. That was a case in the Fifth Circuit in 2015. And then in parentheses, body of victim and car, not tangible object for purposes. And so that was a case about a body being in a car. I guess they had found the victim in a car, that you couldn't use 1519. Like if you destroyed the car with the body in it, I guess you couldn't use this code. And then it goes on to say, videos depicting contact between Mr. Kelly and victims are not objects within the meaning of 1519. Paragraph 5 of Count 5 alleges that it was further part of the conspiracy that in order to conceal and cover up the existence of videos from investigators, Kelly, McDavid, and others agreed to collect the missing videos that depicted Kelly engaged in contact and acts with other persons. A video depicting pornography is simply not the type of quote object that falls within the meaning of Code 1519. Justice Alito, concurring with the majority in Yates, explained that the type of tangible objects referred to by Code 1519 are those used to store information traditionally recorded in paper, documents, and records. Thus, a defendant cannot argue that destroying a computer, for example, that stores records is not criminal because the computer itself is not a document or record. It says a hard drive, however, is tangible and can contain files that are precisely akin to even these narrow definitions. Both record and document can be read more expansively, but adding, quote, tangible object to Code 1519 would ensure beyond question that electronic files are included. However, videotapes that in no sense contain information traditionally recorded in paper documents are simply not the type of objects to which Code 1519 applies. A video of a criminal act is more akin to a fish than a file that stores records traditionally recorded in paper documents. It goes on to say a video is capable of being manipulated or destroyed, but only in the same way that a fish is capable of being cut up, altered, manipulated, or destroyed. The video in this case, like the fish in Yates, was itself the underlying crime. The Supreme Court indicated that the term tangible object was intended to refer to objects that themselves, while not records, are used to store documents and records such as computer hard drives. At least in this case, the videos in questions did not store anything that can be considered a document or record. Sex tapes, quite simply, do not contain information traditionally recorded in paper documents akin to financial records, nor is a video, at least in this case, an object which itself stores records. And then it cites another case, and it says that Code 1590 should be extended, quote, beyond the principal evil motivating its passage. And then it says, finding that by placing the statute among the, quote, specialized provisions of obstruction scheme, Congress indicated that it, quote, was not intended to serve as a cross-the-board ban on the destruction of evidence of every kind. It says statute placed with specialized provisions expressly aimed at corporate fraud and financial audits. Justice Alito's concurrence, finding statute is directed towards, quote, file keeping. Videotapes in this case are not objects connected in any way to financial fraud or financial audits or documentary file keeping, in which Code 1519 was meant to apply. And then it says the undersigned was not able to find many cases directly on point. 2 Seventh Circuit cases appear to uphold the conviction of defendants for violating Code 1519 by destroying media evidence or pornography. See United States Keith, and this was a case in the 7th Circuit in 2011, and United States versus Wortman, which was a case in the 7th Circuit 2007. And it says both, however, were decided prior to Yates, and neither actually involves a challenge based on whether a video depicting a sex act constitutes a qualifying tangible object under Code 1519. And so it says that these cases cannot help the government. So unlike other obstruction of justice statutes, Code 1519 does not require that an act be material to an actual ongoing or imminent federal investigation. Federal, civil, criminal, and regulatory law is ubiquitous aspect of nearly every part of modern life. It is difficult to imagine an object that could not, at least in the hypothetical, relate to a matter within the jurisdiction of some federal agency. Similarly, videos are becoming more and more part and parcel of modern life, allowing the federal government to criminally prosecute anyone who destroys a video that may be potentially relevant to a federal investigation would have the effect of greatly expanding the government's power. The Supreme Court explicitly held that Code 1519 was not intended as a broad provision criminalizing the spoliation of evidence. Yates, which was the case we're talking about, what the Supreme Court heard. And it says, if Congress indeed meant to make Code 1519 an all-encompassing ban on the spoliation of evidence, as the dissent believes Congress did, one would have expected a clearer indication of that intent. Simply put, a video is more like a fish than it is like a spreadsheet or a report. Pornography is a horrible crime and criminal. However, pornography itself is not the type of tangible object that contains records or documents related to financial crimes or file keeping, which is what 1519 was explicitly passed to address. Such videos are not something in which a financial entry can be made as required by Code 1519 and Yates. A video may contain evidence of a crime, but so too can a car or a body or a fish, none of which constitutes a tangible object within the meaning of Code 1519. And it pretty much, the object may memorialize evidence of a crime without itself falling under Code 1519. And I think I said United States Supreme Court Code, but it's actually United States Code. So these are laws that the Congress put into action, I believe is how it goes. Tangible object provision to be criminalized by Code 1519. The object must be of the type that would normally store the kinds of financial records, documents, and entries that motivated Code 1519's passage. The tangible object provision in 1519 refers to objects that contain records or documents, objects into which financial entries can be made. An alleged pornography video is simply not such an argument. Accordingly, Count 5 must be dismissed. So then it goes on and says, B, influencing witnesses to provide false information to law enforcement or false testimony to a state court is not falsification or destruction of an object, record, or document within the meaning of Code 1519. It says paragraph 7 of Count 5 alleges that in varying forms, Mr. McDavid, quote, agreed to attempt to persuade other individuals to falsify and make a false entry in a record, document, and tangible object related to Kelly's conduct and acts with persons. The indictment lists the following specific examples. And these are quotes from the indictment, and I read the indictment when it first came out in July. If you want to go back and hear the whole thing, you can go back and listen to it. A, person one falsified and caused a false entry to be made in a police report when person one denied a law enforcement officers that denied two law enforcement officers that Kelly engaged in relationship with person one. McDavid instructed person one's father to provide knowingly false testimony to Cook County grand jury investigating Kelly's relationship with person one, instructed person one's father to falsely deny to the grand jurors that video one depicted Kelly and person one, thus creating a false record. C, person one falsely denied to the grand jurors, thus creating a false record and a false entry in a record, document, and tangible object. D, Kelly attempted to persuade person 5 to provide knowingly false testimony to the Cook County grand jury. E, McDavid directed that person 2 meet with a lawyer and that person 2 falsely denied that person 2 and Kelly ever engaged in acts together with person 1 and person 2 as Kelly and McDavid intended. A false record, comment, and tangible object was prepared based upon person 2's false statements. Then R.1 at 10 through 11 in summary. Paragraph 7 alleges that Mr. Kelly and Mr. McDavid took steps to convince others to lie to law enforcement to the grand jury. The logic appears to be that Mr. Kelly and Mr. McDavid must have known that those lies would be memorialized in some way and that they therefore knew that a record or document would be created. As an initial point, it is unclear in paragraph B what record might possibly be created, but putting that aside, this logic stretches Code 1519 light years beyond its intended scope. A police report may well constitute a record within the meaning of Code 1519. And it goes on to cite United States versus Moria, which was heard in the Third Circuit in 2012, and United States versus Hunt, which was heard in the 11th Circuit in 2008, United States versus Lanham in the 6th Circuit in 2010. It says these cases involve officers who authored the report themselves, not individuals who provided false information to an officer who might later make a report. The undersigned was not found a single case wherein encouraging another person to provide false information to a law enforcement officer who would then possibly write a report has been charged under Code 1519. Furthermore, the evidence plainly indicates that no false entry was actually made in any report or document. Generally, police reports detailing what a witness says do not certify that the claims made by the witness are true, but rather document the simple fact that these were the statements that the witness made. Nor does a grand jury transcript certify that the facts contained therein are true. It only certifies that the witnesses said the things contained in the transcript. A grand jury transcript is created by the court reporter. The court reporter is not indicating that the statements of the witness contained therein are true. They indicate only that the transcript contains an accurate record of what the witness said. The transcript is the record. There may have been false grand jury testimony as the government alleges, but it does not follow that anyone falsified the record of the grand jury testimony. There is no doubt that the grand jury transcript was an entirely accurate record of what the witness said. Hence, no false record or false entry was made at all. The record in question, the grand jury transcript, accurately reflected that which that which was supposed to reflect the statements made by the witnesses. With respect to police reports in which an officer says that something happened which he knows did not happen, he is making a false report or false record. Such officers are recording as true something that is not. And then it goes on to cite a case, and it says affirming Code 1519 conviction of a police officer because evidence supported that he, quote, knew the information in the report was false. Emphasis original. And then it goes to the Hunt case. And it says that upholding a Code 1519 conviction against a sufficiency of evidence challenged because the evidence showed that the police officer knew he made falsified entries in a use of force report. When a police officer documents a statement from a witness, he is simply recording what someone else said. His report is accurate even if the statement is not. In the police reports in this case, there is no evidence that any officer made a false entry. Section 1519 applies to instances where false entries are intentionally made in records, not when people choose to lie to record keepers. The records in question here, the false police report, the records in question here, the police reports, just like the grand jury transcripts, accurately reflected that which they were supposed to reflect, the statements made by the witnesses. In this case, there are no false entries made in records by either the police or court reporter. This renders these documents outside the ambit of Code 1519, and it says, nor has the undersigned found a single case where encouraging a person to lie to the grand jury has been charged under Code 1519, extending the scope of 1519 to include intimidating another into testifying falsely would render Code 1512 superfluous, as both obstruction statutes would cover the exact same conduct. See Marks versus General Revenue Corp. And that was in a case in 2013. And it says, quote, the canon against surplusage is strongest when an interpretation would render superfluous another part of the same statutory scheme, criminalizing pressuring witness to testify falsely before a grand jury. Hence, Code 1519 must be interpreted not to criminalize that which explicitly covered by Code 1512. And then intimidating or pressuring another to testify falsely before a grand jury or to make false statements to a police officer simply cannot be prohibited conduct under Code 1519, which criminalizes the intentional making of false records. Thus, again, count 5 must be dismissed. And then in part 2, it says that the indictment fails to allege requisite mens rea. And so it says the defendants need not be aware of an ongoing imminent federal investigation to be guilty under Code 1519. However, at the very least, they must act in contemplation of a federal investigation at the time of the alleged acts of record destruction or false document making. For example, in the United States versus Reeves, the district court overturned the conviction of an oyster harvester who provided false documents to a state agency. The oyster harvester had no reason to know that the documents would be provided or had been requested by the FDA. And then it goes on and says that was a case in the District of New Jersey in 2015. And it says the FDA is not the New Jersey Department of Health. The government must prove that Bailey had the intent to obstruct or impede an FDA program in contrast to a state program. And so they go on and cite different cases. And I think what they're trying to say is that whatever happened back in 2002 when the case was being brought against R. Kelly in state court, they had no idea that 10 years down the road that there would be a federal investigation, and that information would be used that was given during the state case would then be part of an investigation that they had no knowledge or no anticipation would actually occur. So you can't charge under this code because there was no contempt. Like, you weren't saying, oh, you know what, 10 years down the road the feds might be investigating me, so I better destroy this information, or I need to get these people to lie in this case because 10 years from now I'm going to be charged on the federal level. And then they say there have been several cases, however, where the appellate courts have upheld the convictions of police officers who falsified police reports. In those cases, courts have upheld those convictions in part because police officers are generally aware that the federal government has the power to investigate civil rights abuses and other police misconduct. Furthermore, the jury also heard sufficient evidence to conclude that the defendant knew his actions were unlawful. As a certified law enforcement officer, the defendant received training that made him aware that, quote, at least in general sense, obstructing a criminal investigation by lying to a federal law enforcement officer is unlawful. And so in this case, the state's investigation into Mr. Kelly began in 2002 and terminated with his acquittal in 2008. R.1, there is no evidence that Mr. Kelly or Mr. McDavid had any reason to contemplate that the federal government would begin an investigation, or even that they could begin an investigation into Mr. Kelly's conduct. Furthermore, there is no evidence that they intended any false statements to be transferred to any federal agents. According to the indictment, they were motivated solely by the desire to impact a state grand jury investigation. Consequently, they were not acting in contemplation of a federal investigation, and Code 1519 does not apply to them. In Part 3, the government failed to establish a qualifying overt act done in furtherance of the conspiracy that occurred after the statute of limitations ran. So it says prosecution for conspiracy is subject to a 5-year statute of limitations, 18 United States Code 3282. In order to convict defendants, the government must allege and prove not only that the purpose of the conspiracy continued within the period of the statute of limitations, but also that an overt act occurred within the statute of limitations. Grunwald, United States versus Yasher, and this was a Seventh Circuit case in 1999, and it says the, quote, crucial question, unquote, is the scope of the conspiratorial agreement. And then Grunwald 353 U.S. at 397 United States versus Norwick. And this was a Seventh Circuit case in 1971, and it says the duration of a conspiracy depends upon the scope of the agreement entered into by its members. Under the general conspiracy statute, an overt act is defined as any act to affect the object of the conspiracy. An overt act need not be a completed offense or the ultimate goal of the conspiracy. It need only be an action taken in furtherance of the conspiracy by one or more of the conspirators. United States versus Hickok, and this was in the Seventh Circuit in 1996. And then they're quoting 18 U.S.C. Code 371 United States versus Murray's, and this was Seventh Circuit in 1980. It says an overt act is one that is within the scope of the conspiracy and advances the goal of the conspiracy. Absent an overt act to further the conspiracy, the continuing results of a conspiracy are not sufficient to extend a conspiracy into the applicable Statute of Limitations, and then they cite a case, Fiswick versus the United States from 1946. A conspiracy ends when its central criminal purpose has been accomplished. United States versus McKinney, and that was 7th Circuit, 1992. Then they cite a bunch of other cases, and it says simply discussing a criminal act or a past criminal conspiracy does not constitute an act in furtherance extending the statute of limitations, and that was from McKinney. And it says rejecting argument that discussing the murder with other members of criminal organization constitutes an overt act because the charged conspiracy was limited to conspiracy to commit murder. If the government had charged a conspiracy to run the Aryan Brotherhood as a racketeering enterprise through a series of murders or some other conspiracy that had ends beyond the defendant's murder, the government's argument would have merit. But the government charged only a conspiracy to murder the defendant. That purpose was accomplished, and the conspiracy could not be extended into the statute of limitations. Acts of concealment are not sufficient to extend the scope of a conspiracy. And that was from the Nowak case. And it says, nor are continuing effects of a conspiracy sufficient to extend its scope. United States versus Doherty. And this was in the First Circuit in 1989. Conspiracy to steal advanced copies of civil service examination and sell them to police officers to obtain promotions was not extended by receipt of increased salary payments due to the ill-gotten promotion. It says A, conspiracy terminated prior to July 11, 2014. In this case, the government charged the defendants with conspiracy to violate Code 1519 through obtaining and covering up videos and through the creation of false records, i.e. state grand jury transcripts and state police reports. R.1. That purpose was achieved, 1. when those records were created, or 2. when the videos were obtained. Therefore, the conspiracy could not be extended into the statute of limitations because purpose of the conspiracy had already been achieved. For example, in United States versus Davis, the Fifth Circuit reversed the conviction for conspiracy under 18 U.S.C. Code 371 to violate 18 U.S.C. 1001 by agreeing to make false statements to the Department of Labor. Fifth Circuit, 1976. The court found that the only chargeable purpose of the conspiracy was to make false statements. Those statements were not made within the 5-year statute of limitations. The ultimate object of the conspiracy alleged in the indictment was to secure payments from contracts for the Department of Labor, many of which were made within the statute of limitations. However, the criminal agreement was to make false statements. After the false statements were made, the conspiracy could not continue. The fact that the constituents an overt act, the fact that what constitutes an overt act is limited by the scope of the charged conspiracy is highlighted by the Seventh Circuit's decision in Nowak. In that case, the defendants were charged with a single conspiracy under Code 371 to engage in various forms of obstruction of justice in addition to violation of Code 1001, 1006, and 1008, as well as Code 657, embezzlement from a federally insured institution. It says the indictment charged and the government proved a broad and continuing conspiracy to misapply the funds of service and to make false and fraudulent statement to an agency of the United States. The false statements were made outside the statute of limitations. The falsely obtained payments and proceeds obtained were received within the statute of limitations. The Seventh Circuit found that in the context, there was sufficient evidence from which the jury could infer that a plot to deceive the government existed into the statute of limitations. The Seventh Circuit noted that it was the second aspect of the conspiracy to embezzle, that extended the agreement into the statute of limitations. The second aspect of the conspiracy was not simply an agreement to conceal the misapplication of services assets. It involved a continuing agreement to commit independent criminal acts by giving false answers to questions by federal regulatory examiners concerning services use of brokered accounts. As was the case in Davis, the government in Mr. McDavid's case did not charge a broad conspiracy to deceive through various means of obstruction, nor did the charged conspiracy involve any other criminal aims outside of obstruction. Rather, the government charged conspiracy to specifically violate Code 1519. Count 5 of the indictment in this case indicates that the grand jury investigation ended on June 5, 2002, with the grand jury indictment of Mr. Kelly for pornography relating to Video 1 and Person 1. Mr. Kelly was acquitted on June 13, 2008. Video 1 was in the possession of state authorities at the time. The indictment alleges that in 2001, Mr. McDavid first learned that videos depicting Kelly engaging in contact with persons were missing from Kelly's collection of videos, R.1 at 8. The indictment alleges that between 2001 and 2009, prior to the 5-year statute of limitations period, Mr. Kelly and Mr. McDavid caused others to be paid for obtaining the videos, R.1 at 8. The indictment alleges that Mr. Kelly and Mr. McDavid induced others to provide false statements to law enforcement for state courts. The last such act occurred in 2007, prior to the 5-year statute of limitations period. The indictment alleges that payments to Person 1 occurred in 2015, but there is no indication of any alleged false statements or false documents being created after 2009. The creation of false documents or destruction of business records is the only conduct criminalized by Code 1519. Making payments to a person who already caused false documents to be created is not criminalized by Code 1519. Therefore, the charged conspiracy to violate Code 1519 does not extend into the statute of limitations because of these payments. Just as in Davis, the purported object of the conspiracy had been achieved prior to these payments being made. The specific agreement charged by the government was to violate Code 1519 by making false statements to the police and the grand jury. The false statements in question were already procured or obtained by 2008 in Cook County. Any acts to conceal Mr. Kelly's conduct from the general public or even from state and federal investigative authorities after 2008 might have been directed at the same general goal that the conspiracy sought to obtain. But if there were no false records to be made because the grand jury was already concluded, such acts do not advance the charged conspiracy to violate Code 1519 specifically. That conduct, while perhaps relevant to other charges in the indictment, is outside the scope of the conspiracy charged in Count 5. If payments were made to prevent Person 1 from any future cooperation with law enforcement, that is simply an act of concealment, which is insufficient to extend the statute of limitations. United States versus Norwood. Section 1519 charges the creation of a false document, not the failure to create a true one. No false documents were created after 2008. The payments were not made in contemplation of any new false statements or documents, and the government has not alleged as much. Thus, the payments cannot extend the conspiracy into the statute of limitations. The indictment specifies only 4 overt acts committed after July 11, 2014. 1. In approximately September 2014, Kelly caused a wire transfer in the amount of $80,000 to be paid to McDavid through his firm. 2. In approximately October 2014, Kelly caused a RSK Enterprise LLC check to be issued to Person 1 payable in the amount of $1,150. 3. In approximately October 2015, Kelly caused a wire payment to be made to Person 1 in the amount of $1,150. In approximately December 2015, Kelly caused a wire payment in the amount of $100,000 to be made to agents of McDavid on McDavid's behalf. R.1. None of these acts could possibly have been taken in furtherance of the conspiracy charged in Count 5. The payments to McDavid, which were noted in the indictment, could not have been in contemplation of the creation of any false or fraudulent document, as no false or fraudulent document was created at or after the time of those payments. The government's indictment does not indicate, even in the hypothetical, that prospective false documents the payments were supposed to be aimed at obtaining. First, as the indictment notes, Mr. McDavid was employed by Mr. Kelly long before Mr. McDavid had any reason to suspect that there may or may not be an investigation into Mr. Kelly's sexual misconduct. In addition, Mr. McDavid's employment was not limited to the criminal conspiracy. Mr. McDavid was Mr. Kelly's business manager. R.1 at 5. The indictment alleges that, quote, as a manager for Kelly, McDavid was involved in providing services to Kelly, which services were in part intended to protect Kelly's image, reputation, and assets in the face of actual potential criminal and civil actions involving individuals who were victims of misconduct by Mr. Kelly. While perhaps not the most laudable or possible occupations, protecting a celebrity's image and reputation does not, at least without more, constitute a criminal conspiracy. And payments made to Mr. McDavid for the purpose of protecting Mr. Kelly are not overt acts in support of the charged conspiracy to violate Code 1519. Second, and perhaps more importantly, at the time the government alleges those acts occurred, the false documents and statements about which the government complains in the indictment had already been obtained and or created. In that sense, the case indeed directly analogous to Davis from the Fifth Circuit. The government charged a conspiracy to violate a single obstruction of justice statute aimed at making false documents and record manipulation and destruction. The government does not allege that any acts of document destruction or false record creation were actually sought by the defendants with the applicable statute of limitations, period. Nor could the payments to Person 1 be in furtherance of the charged conspiracy. The payments could not have been made to conceal Video 1 as noted in the indictment. The state had already access to Video 1. It was played during Mr. Kelly's trial in Cook County. An act must be in furtherance of the conspiracy in order to extend the conspiracy into the statute of limitations. Example, it must advance the criminal agreement of the conspiracy in some way. The payment could not advance the concealment of the video referenced in the indictment because the video had already been unearthed. The payment could not advance the creation of inaccurate police reports or grand jury transcripts because those reports and transcripts had already been prepared and completed. If anything, the checks allegedly written to Person 1's family can only be acts of concealment. That is not sufficient to extend the scope of the conspiracy that has otherwise come to an end. without any overt acts within the statute of limitations which could actually extend the conspiracy, count 5 must be dismissed. Wherefore, this honorable court must dismiss count 5 of the indictment as it relates to Mr. McDavid because the government's attempt to stretch not only the scope of Code 1519 but also the statute of limitations far beyond their intended reach cannot succeed under the law.